I've got my legal assistant, Kim Hearn, Mr. Stock, and Mr. Dave Harvey. And Mr. Austin Moylan from my office is listening in today, but will not be participating, Your Honor.
All right, welcome to you all. So we're here for an evidentiary hearing on the application for order show cause. Hopefully you all got my ruling on the motion to quash. I wanted to just kind of run through, obviously my goal is to make sure that everybody has a chance to present their evidence and I have a chance to hear it all and get the result right based on the law. So I have you set for a full day. We typically go till 4:30. What that equates to, we take a mid-morning break, which we will do at around 11. I won't cut you off if you're in the middle of making an important point, but around that time, we'll take lunch from 12 to 1:30, and then we will also take an afternoon break around 3. So I try not to force anybody to be sitting without a break for more than an hour and a half. If anyone needs a break before the set time, I don't want you to suffer in silence. Just let me know, signal to me that you need a break, and we can take a break at a different time if anybody needs to. I have, because that amounts basically with breaks to about 5 hours, I split that time equally on both sides of the V. I have a little chess clock that I use to keep time as accurately as possible. If objections start to become out of control by one party during another party's examination, I may flip the clock, but generally I will start and stop anytime you're speaking. It'll come off your time. And if you want a time check, you can ask me. If I start to get worried about you running out of time, I'll let you know. I wanted to, before we get started, just talk to you about I'll warn you that sometimes I may reserve rulings on things just to keep things moving, but you certainly have have an opportunity to object to anything you want to object to. And I know there were some objections by the plaintiffs to testimony from the defendant's declarations, but one issue I wanted to talk with you about was the truck appraisal, because there was a indication that there's no dispute as to the value, the March 2025 valuation, but then there were objections to the appraiser's testimony, I think. So I wanted to see if we can clean that up, if that might streamline. I recognize that stipulating to the amounts set forth in the appraisal isn't a stipulation that was a part of the party's agreement as to the allocation provision, but I just wanted to see if there was some chance to resolve at least whether or not that's disputed and maybe save some time today. Mr. Pack?
Yeah, Your Honor, we're not going to challenge their valuation at 800, whatever it is. Like you said, we don't agree that there was an agreement that would be the fair market value, but we don't have our own valuation evidence to present. So if they want to just admit that their appraiser's declaration as is, fine. I do have some questions for him on cross-examination, but they're going to be very brief.
Okay. And then, all right. So we do still need to call him as a witness then.
Yeah, but I don't think my cross is going to be more than maybe 10 minutes.
All right. Are there any other exhibits that you all and I received your separate pre-hearing statements. I know life gets crazy. I'm not faulting anybody for those coming in separately, but if you hopefully you have a chance to get the clerk's list which tends to be different from your numbering. Are we able to stipulate in any of either party's exhibits to save some time as well? And if not, that's okay. We can stipulate them in as they come.
Well, how do you want to handle the declaration? Should those be admitted as exhibits?
I typically don't admit them as exhibits because they're already filed and on docket and a part of the record. We can admit them as exhibits, but I don't think it's necessary to admit them as exhibits in order for me to consider them as evidence.
Okay. Let me just take a quick look at their exhibits. Defendant's Exhibit 5, we can stipulate to. That's the settlement agreement.
Okay, defendant's 5 is admitted.
6, we can stipulate to.
Defendant's 6 is admitted.
7 is just the IRS form and the instructions.
Correct.
All right, that we can stipulate to.
Defendant 7 is admitted.
I think 8 we can stipulate to as well.
Okay. Defendant's 8 is admitted.
And 12 is just your proposed order.
Exhibit 12, yeah.
Yeah, then 12 we can admit to, we can stipulate to as well.
Okay. Defendant's 12 is admitted. All right. What about any of plaintiff's exhibits?
Your Honor, generally, we don't have any objections. There are just, I guess, so I was hoping to address some of the housekeeping stuff, so I appreciate Your Honor bringing these up. So our exhibits 10 and 11 are part of the email chains that are contained in their exhibits 11, 12, 13, and 14. And I can walk Your Honor through those to show you how, in fact, one of them is contained expressly in one of their emails. And the other is a response to one of the plaintiff's exhibits email change is a response to an email from my office. So it's all part of the same chain. So under the rule of completeness, we would contend that those should come into evidence. There'd been an objection to their 408 conversations, but Your Honor, I guess a few things. One, to the extent they're including the whole other chain, it's the same conversation. So they waived any 408 protections. And under the rule of completeness, I think we're entitled to have those communications be before you so that you can have the full picture of them.
Okay. And just to be clear, you're talking about your exhibits 10 and 11 as compared to their exhibits
11 through 14, Your Honor.
11 through 14. And what you're telling me is that your 10 and 11 are just part of the same email chains that are set forth in their 11 through 14,
That's correct.
but they're not included already in 11 through 14.
Part of exhibit 11 is included. It's just that, or excuse me, part of 10 is included. The body of the email is included expressly in theirs. It just doesn't have the attachment, and ours has the attachment to it, Your Honor.
Okay. And Mr. Pack, if they stipulate in 11 through 14, will you stipulate in their 10 and 11 for completeness purposes?
No,
Okay.
I was only going to use 10 and 11 for rebuttal, so I haven't offered those exhibits yet.
Well, here's what I'll tell you then. Let's just address it when it comes up. That is, if we can't stipulate it in, then it's easier to just for me to see it as it's being discussed.
I can cut to the chase on this. We'll stipulate to the admission of 11 through 14, subject to them being 10, 11. So we listed any other exhibits listed by them. So we'll stipulate to the admission of those exhibits. We do intend to use them.
Okay, but so tell me again which exhibits on plaintiff's list you're stipulating to. So you're stipulating in 11 through 4, plaintiffs 11 through 14. So plaintiffs 11 through 14 are admitted.
Correct.
Any others?
Let me see, Your Honor. Your Honor is not inclined to do declarations. Is that correct?
I just don't think it's necessary.
That's fine, Your Honor.
If you all want to, we can.
That's fine, Your Honor. I think there's some duplicates here, but I think, looking at it, Your Honor, other than 1 and 2, which are the declarations, we would stipulate to 3, 4, 5.
Six is a duplicate.
Yeah, 6 is a duplicate, and then we would do, and 9's a duplicate as well, Your Honor. We will stipulate to 7 and 8.
Okay, plaintiffs 3, 4, 5, 7, and 8 are admitted.
And then we'll stipulate to exhibit 10, Your Honor.
Plaintiff's 10 is admitted?
And that's it, Your Honor.
Okay. All right. So those are admitted. Did you all want to give opening statements? Obviously, we've had a lot of briefings, so it's not necessary, but if you want to, I'll allow you to do that.
I think you've had enough paper and you're pretty well familiar with this case, so I don't think it's necessary either. If Mr. Freeman wants to make one, that's fine, and I just reserve our right to do a closing statement.
Your Honor, we don't need an opening statement either. I guess there is one other exhibit I was hoping to talk about, Your Honor. Our Exhibit 9.
Okay.
The declaration of Faith Straubing, which we provided, has the business records that she created the spreadsheet from the business records. The objection was foundation and hearsay. I think that accomplishes that. It would, to me, it'd be a shame and a waste of the court's time to call her to ask her those specific questions. And that would be the only reason we would call her, is to testify as to the basis for admission of the spreadsheet that she prepared, Your Honor.
She's an employee of WJS and STL, not FedEx. She doesn't have the competence to testify as to FedEx's business records, and that's effectively what this is. This is a summary of the business records of FedEx as to when they, according to Mr. Freeman, transferred the truck routes. So I don't think that she is competent to provide that business records foundation.
All right. Well, then, in light of that, I'll have to reserve my ruling and I'll hear some testimony from her. Any other?
No, Your Honor, we're prepared to move forward.
And I'm hoping that because I received and reviewed your declarations, we'll be starting with cross-examination. I assumed that defendants were going to go first, then plaintiffs, then rebuttal, because you have burden on the application.
That's fine, Your Honor. And I guess depending on the order of sequence, does Your Honor propose that we cross-examine their witnesses before we provide our rebuttal?
No, what normally happens is whatever witness you are calling first, we'll put them on the stand, but we'll start with cross-examination if they've already given a declaration. Does that make sense?
It does, Your Honor. I guess, given some of the objections that were made, for example, I would call Ms. Straubing to testify the foundation of that.
Sure. And if you need to lay some additional foundation, that's fine. So who are you calling first?
Your Honor, could I just add one thing quickly? I know we want to start with cross-examinations on these things, but believe both Mr. Cantara, who's our witness, and Mr. Walters had small things that they wanted to clear up on their declaration. So if we could just call them to clear up those few items before Mr. Freeman moves on to his cross, I'd appreciate it.
That's fine, and that's what he's saying with respect to Ms. Straubing.
Got it.
So, yeah, would you, Your Honor, like us to proceed then first?
Yes, you can call your first witness.
Okay. She's going to appear virtually, Your Honor, so it may take a minute. So again, I hate to use the court's time. So let me go ahead and call Mr. Harvey. We'll start with him.
Okay.
And we'll arrange for Ms. Straubing to follow up to be available after he's done. So
Okay.
We'll call Mr. Harvey.
Okay, Mr. Harvey, if you'll kind of come back, there's a little walkway here to the left. Sorry, you went the long way. And once you get settled, if you'll just remain standing and raise your right hand, our clerk of the court is appearing remotely and she will get you sworn in.
You do solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you, sir. You can have a seat there. If you will do your best to speak into the microphone just to make sure the FTR, our recording, is picking you up, and there is water to your left if you need it.
Gotcha.
And
Harvey. Yep.
Mr. Freeman, are you going to ask any questions, or can we proceed to cross-examination with Mr.
I just wanted to ask a couple of
Okay.
questions, Your Honor,
No problem.
in light of Your Honor's ruling, and just to clarify a few points before the cross-examination. Thank you.
And you can proceed whenever you're ready.
Thank you, Your Honor. Mr. Harvey, did you prepare a declaration or work with my office to prepare a declaration containing your direct testimony for this case?
Yes,
And is the information in there true and accurate to the best of your knowledge?
yes.
Okay, let me have you look at Exhibit D5. We're going to turn to page 3. Paragraph B. Take a second and read that if you would, please. You can read it to yourself.
Just to clarify, because we're not admitting the declarations. This is the declaration of Dave Harvey, CPA, that was filed on July 29th, dated July 29th, 2026, and is a part of the filed record. Go ahead.
Thank you.
Okay,
Okay, so you've read this paragraph before, right?
correct.
Okay. And so you're the CPA for STL and WJS, right?
That's correct.
Okay. And so when you read a sentence that talks about allocation for tax purposes, what does that mean to you?
Allocation for tax purposes would mean how a selling or a purchase price is allocated to specific assets. It could be cash, could be accounts receivable, could be trucks, routes. It's how the allocation of the purchase or sales price is to specific assets.
Looking at this particular sentence, what are the categories that are being allocated to?
Your Honor, I guess at this time I'd renew the objection that we made in our joint pretrial statement, especially in light of the court's ruling that the only thing that's really at issue today is the parties' agreement and whether the parties had it. And Mr. Harvey was not, by his own admission, involved in the negotiations. His testimony is irrelevant.
Thank you, Your Honor. Two things. One, for tax purposes is the express language in this paragraph. It's the qualifier. So it can't be taken out of context to say this allocation is for any other purpose. So Mr. Harvey can certainly testify as to the seller's intention or understanding of what this for tax purposes means for purposes of an allocation.
Okay, I'll give it the weight it deserves, but I'll overrule the objection.
So, Mr. Harvey, let's look at Exhibit D7, please. Let's go to page 4. So look at the left-hand column there, Mr. Harvey, under note.
What page of
Page 4.
And we're looking at Defendant's Exhibit 7?
That's correct, Your Honor.
Okay, that's page 4 of your exhibit. What page of the instructions is it?
Page 2 of the instructions.
Thank you.
You see that language, Mr. Harvey?
Yes, I do.
Okay, and so pull back out, Jim, for just a second. But this section, this note's referencing equipment, correct?
Yes, it's basically, it looks like tangible equipment, buildings, land, vehicle, equipment. Yeah, tangible goods.
Okay, and what class are those being listed under?
Last would be generally class V.
Class 5?
Yes,
Okay. And so in the agreement, it said goodwill, equipment, and routes, right?
correct.
So when you see equipment in the context of that agreement, what does that mean to you?
Well, this again would be the tangible goods. This would be the trucks.
Okay. Were there any other assets, let's strike that, would goodwill or routes be classified under class 5?
They would not.
Okay. And with respect to an asset being classified in class 5, is there a limitation in these instructions about how you treat that equipment?
tangible goods can be valued, and that would be the fair market value.
So let me have you slide over to the right there. In the paragraph that just starts right there, it's the amount allocated. Do you see that?
I do.
Okay, read that for the court, please.
The amount allocated to an asset other than Class 7 asset cannot exceed its fair market value on the purchase date. The amount you can allocate to an asset is also subject to any applicable limits under the Internal Revenue Code or general principles of taxation law.
So is this a recommendation, a suggestion, or an actual limitation from your perspective?
Well, it's very direct, cannot exceed its fair market value. So that is pretty clear.
Okay, so let's look at Exhibit D8, please. And go to page 19. The PDF. Just passed it.
Your Honor, while we're getting there, I would just object to this testimony as duplicative of what he said in his declaration. I mean, the declaration's there. It sounds like he's just reiterating what he said in the declaration.
Okay, well, I'm going to give you both leeway to present what you need to present live, and I'll extend the same to you. So the objection is overruled.
Mr. Harvey, have you seen this valuation?
Yes.
Okay, and so based on this valuation for STL, the trucks were worth $347,500.
That is correct. That was the value.
Okay, and so based on what we just saw in the instructions to the form about allocations to equipment, it would be limited to that dollar amount for STL, wouldn't it?
Yep. Class 5 is limited to fair market value. So these trucks would be $347,500 for STL. WJS, fair market value would be $460,500, and that's fair market value.
That's all I have, Your Honor.
Cross-examination?
Yeah, Mr. Harvey, Mr. Freeman started by asking you, by showing you the party settlement agreement and asking you what a particular phrase in that agreement meant to you. I believe it had to do with for tax purposes. But let's be clear, you were not involved in negotiating that settlement agreement, correct?
That is correct.
And you did not participate in the mediation that led to that settlement agreement, correct?
Correct.
And you didn't participate in the drafting of that allocation language, correct?
That's correct.
In paragraph 14 of your declaration, you say that my involvement relevant to this proceeding began when I was asked to assist sellers in accounting for and reporting the sales of the STL and WJS business assets for federal income tax purposes. When was it that you were asked to assist the sellers in accounting for and reporting the sale of those assets?
Well, I think we started working with Wally in this transaction in February 25. And I would say it's our sole role to determine the purchase price or selling price. And then the second would be how to...
Mr. Harvey, respectfully, I just asked when
Okay.
you got involved, and I think you've answered that question. So you said that you got involved in February of 2025, is that correct?
Correct.
And if we take a look at Defendant's Exhibit 5, can we bring that up, please? Defendants. You're looking at you've got the wrong case pulled up. Your Honor, I apologize. We've got the wrong case pulled up on case lines. All right, so Mr. Harvey, that settlement agreement that you were talking about, your interpretation of, that's signed or that's dated as of July 31st of 2024, correct?
Correct.
So you were not asked to get involved in preparing tax returns or doing any work interpreting this until roughly 7 months after this agreement was signed. Is that correct?
Yes, I was engaged February 25, so from July to February.
And in your declaration, you spend a lot of time discussing IRS Form 8594 and the instructions. And your proposed allocation, how you think the parties should report the transaction in their Form 8594s, that's based on your interpretation of the federal tax code and the federal tax regulations, correct?
Yes, however, you have to look at the agreement to determine how to allocate.
Well, would you agree with me that the agreement only says the parties agree to allocate X dollars to goodwill and Y dollars to equipment and routes?
That's exactly what the agreement said.
And the agreement doesn't say anything, it doesn't provide any of the allocations that you said are proper in your declaration, correct?
If it's not spelled out in the agreement, you have to deal with the issue.
Okay, so my question though is the agreement does not say the parties shall allocate, excuse me, let me turn to your declaration. The agreement does not say anything along the lines of the parties shall allocate $2,587,500 per company to goodwill, and then for STL, $347,500 for trucks, and $826,514.83 for routes for STL. Does it?
Objection, Your Honor. We don't know where he's going with this. I don't know what he's talking about or what document he's referring to, and I don't think the witness does either.
I'm referring to his declaration. It's paragraph 66 of his declaration that I'm reading.
Okay, overruled.
Can I see that declaration?
Sure. Can you pull up defendant's exhibit number 2? This would be on page 8. So paragraph 66. All right, do you see paragraph 66?
Yes.
That's what you're saying, in your opinion, the parties should report as the allocation of the purchase price, correct?
Yes.
But the agreement that the parties have does not say the parties will allocate $2,587,500 to goodwill for STL, $347,500 for trucks, and class 7, $826,514.83, correct?
Well, goodwill is spelled out in the agreement, and trucks and routes are combined in the agreement. And so to prepare tax returns, you have to go through the calculation, determine how to allocate the sales and purchase price.
Mr. Harvey, respectfully, I don't think you're answering my question. My question is, these numbers aren't contained anywhere in the parties' settlement agreement, are they?
No, the settlement agreement doesn't address this.
Okay, and you said that the agreement does specify the amount to be allocated to goodwill, but in fact, that amount that's specified in the agreement was not $2,587,500, was it?
I think there was an adjustment to the sales and purchase price, which is not addressed in the settlement agreement.
Okay. The settlement agreement also doesn't state that the parties shall allocate whatever is determined to be the fair market value of the trucks to class 5 and the remainder to class 6, does it?
I've been practicing tax accounting for many years. I don't think I've ever seen an agreement spell it out like that. It's the duty of the parties to come to an agreement.
You know, that's interesting that you say that it's a duty of the parties to come to an agreement, because the IRS doesn't actually require the parties to a sale transaction to agree upon an allocation, does it?
I think it's our duty as tax accountants to avoid any IRS issues. And over my period of practicing, I've never had an 8594 that did not agree.
Yeah, you're not answering my question, sir. My question is, does anything in the tax code or in the Treasury regulations actually require that the parties agree upon an allocation of the purchase price in a sale transaction?
There is one box on Form 8594. If parties agree, you check that box.
And if the parties do not agree, you would check the box that says no. Isn't that right?
I don't think there's a yes or no. I think it's just one box.
Well, let's take a look at Defendant's Exhibit number 7. Let's go down to question number 5 on that box. And you can see right there, there's 2 yes or no check boxes. Did the purchaser and seller provide for an allocation of the sale price in the sale contract or in another written document by both parties? And then you have the option to check yes or no, correct?
Yes, you check yes.
And then below that, it says, if yes, are the aggregate fair market values listed for each of asset classes 1 through 7, the amounts agreed upon in your sales contract or in a separate written document? And then you can check yes or no, correct?
You would check no if not agreed.
So then wouldn't it make sense that the IRS does not have any type of, that nothing in the tax code or in the Treasury regulations actually requires the parties to agree upon an allocation?
You are correct. That's not what we do in our profession. We try to always not involve the IRS in issues.
Yeah, I'd move to strike that last part of his testimony after that's correct as non-responsive.
Granted.
Mr. Harvey, part of your opinion is that the Internal Revenue Code requires parties to value Class 5 assets at their fair market value, correct?
Correct.
Wouldn't it be fair to say, though, that fair market value, it's not an objective fact, like, say, the Earth is round, correct?
I'm not sure how to answer that.
Well, 2 people can have different opinions of what the fair market value of a particular asset is, and both of those opinions could be reasonable, couldn't they?
They could be, but there are appraisers or valuers out there.
Okay. The settlement agreement between the parties, you talked a little bit about the adjustment to the purchase price, right? And you said you believe the parties agreed at some point later that they were going to adjust that purchase price. The settlement agreement that you reviewed, that doesn't say anything about how those adjustments to the purchase price are going to be allocated, does it?
No.
Have you read any document that discusses how that adjustment to the purchase price is going to be allocated?
Say that again. Say that again.
So you said that you didn't see anything in the party settlement agreement, the one that we looked at and put up on the screen, that said how that adjustment to the purchase price is going to be allocated. In preparing your declaration and preparing for your testimony today, did you review any other document that discusses how those adjustments to the purchase price were to be allocated?
No.
Nothing further.
Redirect.
Thank you, Your Honor. Mr. Harvey, you did grab that exhibit that was just up and put it back up. You did read the instructions to the form 8594, correct?
Correct.
And didn't that tell you how you would measure equipment for purpose of the agreement?
It's based on the fair market value of tangible goods.
In reading the word equipment in the settlement agreement, did you need to draft it to understand what equipment meant for tax purposes?
No.
Okay. And have you done these before, Mr. Harvey?
You know, we've done so many of these, and we take the same process every time.
And would you interpret, given those instructions, would you interpret an allocation to equipment that exceeded the fair market value? Strike that. Would you advise a client to approve an allocation that exceeded what the tax rules allowed?
No.
Okay, so let's go back to we were on his declaration, please, that calculation. I think it's page 8. So Mr. Pack asked you about a couple of numbers here, right?
Correct.
And we're talking about the $2,587,500, right?
Right.
And after the original settlement agreement, there was another fight and some adjustments made to the purchase price and some other consideration acknowledged, right?
That is correct.
Okay, Your Honor, I'm going to, let's pull up Exhibit D10. So, Your Honor, this is the one that's not admitted to evidence yet. I guess I want to go ahead and address this with the court before we get into questioning. I want Your Honor to look at this screen right here, and then I want you to pull up Exhibit P13 and go to page 5. And I don't know if you can do a split screen, but if you can, please do.
I tend to pull them up on Case Center myself because my eyes are not great, and for some reason, the evidence view makes my screen really small here.
Uh-oh.
So we're looking at Defendant's Exhibit 10 and Plaintiff's.
Plaintiff's Exhibit 13, Your Honor, at page 5.
And it's exhibit what?
13.
Okay, I've got them.
Wait a minute, that's not 13. It's not 2. This is 10. Okay, well then let's start with D10, please. Okay, I guess we can't pull them both up, Your Honor, so we'll just start here. This is an email from Mr. Pack dated December 30th, 9:02 a.m. to me and others. Okay, now go to Plaintiff's Exhibit 13, page 5. And go towards the bottom of the page, please. There you go, right there. Brad Pack, December 30th, 9:02 a.m. to me. Same email, Your Honor. They don't attach the attachment. That's in D10.
Your Honor, we can stipulate it's part of the same email string. I don't think that addresses the issue.
You're under the rule of completeness. There's no basis to exclude D10.
I haven't
Already-
offered that exhibit yet, Tony.
Well,
Excuse
13
me.
is in because it was stipulated in.
Oh, well, but I hadn't, he stipulated to it, but I hadn't offered it as an exhibit. I marked that for purposes of the hearing because at the time I was going through and picking out our exhibits, I didn't know what exhibits he was going to use. So I wanted to mark it for purposes of rebuttal in case we needed to address it.
Why don't we back up? Let's just talk about Defendant's Exhibit 10. What is your objection to Defendant's 10?
It's a Rule 408 privileged settlement communication. This is
Okay.
Mr. Freeman said, we think the allocation should be this. We said, we disagree. Here's what our allocation would be. Can we come to an agreement on these things? And the purpose of that is because we were trying to avoid exactly what is going on today.
So it's a 408 communication, although under 408, sometimes 408 communications can come in for other purposes. Is there another valid purpose that I can consider this other than completeness? Because I'm not going to be inclined to include it for completeness.
Your Honor, they waived Rule 408 right here. The same email is attached in his exhibit that's in evidence. They can't propose exhibits and use them and then say it's Rule 408. But secondly, Your Honor, it's not for the truth of the matter asserted. It's not to show what they did. It's to show a number that he just criticized Mr. Harvey for using. I'm showing the source of that number.
Let's do this. I'll reserve my ruling on this.
Very well.
But everybody, I think, has made their record as to why it should and shouldn't be considered.
And actually, you know what, Your Honor? Never mind. We're just going to scroll down right here. This one's in evidence. Please scroll down to the next page. Mr. Harvey, what's the number listed for class 6 and 7 intangibles there?
$2,587,500 for both WJS and STL.
Okay, and this, just for clarity, let's scroll back up to the first page of that page right there. So this is from Mr. Pack, correct?
That is correct.
Okay, so let's go back to your declaration. Please. Does that refresh your recollection where you got the number 2,587,500?
That does.
Okay. When you look at an agreement that's provided to you to make an allocation for an aim, let me back up for a second. If the parties say in their agreement that they're agreeing to an allocation for tax purposes, what form would you fill out to address that agreement provision?
An asset acquisition, you always fill out Form 8594.
Okay. And from your experience, would a party have to say in the agreement, we're going to put equipment at fair market value to understand that that's how you interpret the phrase or the word equipment?
We always look at it various ways. We did originally think we could allocate routes and goodwill based on the tax basis of these assets, routes and equipment. 100% of the allocation would have went to routes. And so your second conclusion is you seek fair market value. And that's what occurred with these 347.5 and the 465. That's the fair market value of the trucks.
Nothing further.
Thank you, sir. Now we're done with your testimony, so you can step down from the witness stand. You're free to stay, but you're also welcome to go.
Okay.
We would call Miss Faith Straubing at this point, Your Honor.
Okay.
She's going to appear virtually.
All right, great. Okay. Do we have her in the lobby?
I am here. Can you hear me?
There she is. I don't know why my,
Yes, we can hear you.
we can. I'm just trying to maximize you on my screen. Okay, good morning, Ms. Straubing. I am Judge Julian. First, we're going to have you raise your right hand and get you placed under oath.
You do solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, you can put your hand down and Mr. Freeman, you can proceed.
Thank you, Your Honor. Good morning, Ms. Straubing.
Good morning.
Are you employed by WJS and STL?
Yes, I was
What was your position there?
office manager.
Okay. I'm going to show you what's been marked as Exhibit D4. Well, excuse me, not D4. I'm going to show you the declaration you prepared, okay? We're going to pull it
Okay.
up on the screen. Do you recall working with my office to prepare this declaration?
Yes.
Okay. And I'm going to turn you to paragraph 4 of that document. Take a moment and read that if you would, please.
Yes.
Okay. So do you recall providing us with that information about the spreadsheet?
Yes, I did.
Okay, so I'm going to show you what's been marked as Exhibit D9. What is being depicted by this spreadsheet, Ms. Straubing?
On the left, it shows the truck numbers, and on the right, it shows the dates that those trucks and the route that was linked with those trucks were given over to TCW. We stopped servicing them, and they started on that date.
Okay, so before the date listed for each truck was in this particular category, this STL truck, whose possession was it in?
Before the date on the right, it was ours.
Okay.
STL WJS.
And how did you know that it was no longer going to be yours? What happened on that date that you show here as being transferred?
They came and picked up the trucks, and that was the date that we stopped servicing those routes. We no more had anything to do with it. They took over the operation from there for that truck, for that route.
Okay, and you created this document based on the information from your business records there at STL and WJS?
Yes.
Your Honor, I move the admission for Exhibit D9.
Objection, it's hearsay. She hasn't provided any foundation that shows that she is competent to testify as to when FedEx approved the transfer of each of the routes. Number one, this spreadsheet is a summary of business records, and they haven't made the actual underlying business records themselves available. But number two, it appears to be the business records of FedEx and not STL or WJS. So she can say these are the dates when TCW retrieve possession of the trucks, but I don't think she's testified to anything that proves she's competent to say when FedEx approved the transfer of each of the routes to the buyers, which is what this exhibit is being offered for.
I think she's laid the foundation to testify as to what this document is. My struggle is that it really is a summary of business records, and I can only allow a summary in under Rule 1006 if the underlying records have been made available. Were they made available?
Your Honor, I guess I don't view this as a summary exhibit. It's one she prepared. Let me do some follow-up questions, Your Honor, because I don't believe this is.
Because what I'm hearing is that she prepared this at your request in anticipation of litigation, which wouldn't make it in and of itself a business record.
Fair enough, Your Honor.
Okay.
Ms. Straubing, why did you prepare this list?
Because after I started it, after the routes had started beginning to be transferred, we started getting calls from FedEx asking us about mileage on the trucks and saying that they were missing mileage and they wanted us to retrieve that for them. but it had been taken over by TCW. And so we were having troubles throughout the business trying to keep track of everything. And so we wanted a record. I wanted a record for payroll, because this is also the date that the people that ran these trucks were, I no longer had them on my payroll anymore. The number one. And the other one was to be able to talk to FedEx and let them know when it was taken over, to say, I can't get you that information. It was taken over by TCW before that time, and that's why I started it. Just for my records, just so I could keep track of the business that I was trying to wrap up.
And was it challenging during that time, trying to manage trucks being picked up by TCW?
It was extremely challenging because of the way FedEx was doing it. They were doing, a few trucks a day, here and there. It wasn't like the entire route or the entire company was taken over in one day. They did a few days here, a few days there. They did it throughout the month of March.
And
so it was very difficult as far as record keeping went, to try and keep it straight.
Your Honor, I would remove the exhibit.
I'm going to overrule the objection. Defendant's 9 is admitted.
Thank you, Your Honor. I have no further questions of this witness.
Okay. Cross-examination.
Ms. Straubing, your exhibit number 9, and can we pull that back up, because we just switched to our computer. Your exhibit number 9, you said on the left-hand column there are truck numbers. Do you know when those truck numbers were assigned?
When they were assigned to who? To TCW or to our company?
Those numbers that are on the left-hand column. I'm not sure well, first of all, who are you saying those truck numbers were assigned to?
Those were our truck numbers.
Okay, so those are your truck numbers on the left-hand column?
I believe those are our truck numbers.
Okay. You don't work for FedEx though, do you?
No, I do not.
I don't have anything further.
Any redirect?
No further questions, Your Honor.
All right. Thank you for your time today, Ms. Straubing. So your testimony is done. You're now free to go, and you can drop off the Teams Court Connect that you joined for your testimony today. All right.
Thank you.
You can call your next witness.
We'll call Mr. Stock, please, Your Honor. Actually, before we do that, Your Honor, I think I may call my appraiser just to get him out of the way, and can you see if he's available real quick? And I don't know if counsel is open to it, but we could maybe take a quick break here and so we're not using the court's time to arrange for the witness to show up.
We can take a break now. Why don't we take our mid-morning break? We'll come back at 10:45.
Thank you, Your Honor.
Okay, if I stay in here?
Yes, that's perfectly fine. We are off the record.